Hello, everyone. Good afternoon. It's Elis Gomer and Luke Harris with you for this seminar today on what we've entitled Sharp Practice and Sharper Elbows. Um, we want to cover uh, underhand conduct in litigation and the strategies, or certainly the court's approach to that, and also ways to detect and deal with it if it happens in cases of yours. Uh, we are going to be speaking for probably 40 to 45 minutes. As I'm sure all of you will know by now, there is a Q&A box in the window. If you have any questions or observations that you'd like to share, either openly or anonymously, please do feel free to put them in the box and we will come to them at the end. As I say, the seminar idea came about largely because of some recent cases, which I'll come to towards the end of this presentation. And in many ways, the thought, slightly disquieting that it is, that the possibility for uh, improper conduct in litigation may now be, thanks to technology, more prevalent than ever. And so the way we're going to deal with this is that I will set out some basic principles and examples early on. Luke is then going to try and uh, go through some of the cases, including a case which he had particular experience of, to clothe that framework with more detailed statements of principle. And then I will come to the more recent cases that I referred to a moment ago towards the end. So, what do we mean by improper conduct? It is scarcely a novel observation to say that litigation is a high stakes business and that litigants will sometimes feel driven to bend or even break the law in seeking to present their case as they would see it to its best advantage. And we draw the distinction here between misconduct or underhand conduct, which is an attempt to subvert the litigation process or otherwise tip the scales improperly. That is distinct from aggressive litigation, which I would characterize, and this is a subject on which there is a wide range of views. But if we define aggressive litigation as a robust or an uncompromising approach, but which nonetheless stays within procedural boundaries, whether or not people consider that to be a productive or a proper approach is a different question. But for today's purposes, we'll be focusing on the unequivocally improper. The question arises as to how we identify it and what do we do when we do, and what does the court do when it identifies misconduct of that type. Uh, it is impossible, I think, to be entirely comprehensive because there are as many different types of misconduct as there are litigants. But by way of some examples, there is a case we'll come to towards the end where a claimant orchestrating a sting against the defendant solicitor with a view to obtaining privileged information, suppression of evidence, or on the other side of that coin, an attempt to misuse privileged information or evidence that was disclosed in error, the concocting of evidence or documents, misleading the court about otherwise genuine evidence, or the attempt to coach witnesses. That is the tip of an iceberg. We know certainly there have been many examples in recent months as AI technologies develop of the way that very superficially plausible documents or images or even videos can be created using AI. I would suggest that it is entirely possible that we will see that type of technology deployed in this form of misconduct. I'm not suggesting that the use of AI per se is problematic, but it clearly gives rise to some possible improper avenues. And as I've said at the bottom of that slide, many of these situations will, by definition, involve conduct by litigants which they are carrying out without their legal team being aware of it. And so that can be another aspect of this phenomenon, which is troubling. All of this comes under the broad umbrella of abuse of process. Luke, as I say, is going to cover this in more detail, but by way of some introductory points, abuse of process, as we know, comes in different forms, and the court's judgments on abuse of process tend to focus on how it's often difficult to define exhaustively, but it's one of those things that tends to be you know it when you see it. There are two broad categories, one which is concerned solely with the quality of the behaviour, which we can call, by way of shorthand, actual abuse, and another type which is concerned with the impact of that behaviour on the possibility of a fair trial and the integrity of the court's process. And as we've gone on to say in the second paragraph on that slide, it's possible for abuse of process to occur through steps taken outside the litigation. And the court jealously guards its jurisdiction and the way that it determines litigation between the parties fairly. The type of behaviour we are going to describe here is effectively an attempt to cheat the system. And even though that abuse is not procedural in a formal sense, it is nonetheless behaviour which seeks actively to undermine the court's procedures. And so the court will actively take steps to guard against it. There are any number of reasons why people feel driven to embark on conduct of this type. Sometimes it is a litigant who genuinely believes they have a strong case, but who feels driven to want to present that case in its best light and or shortcut the process. They might be seeking to bolster a weaker case that's nonetheless brought in good faith. Or at the other end of the spectrum, it might be behaviour in support and in the service of an actively untrue case that they know to be untrue. And so it's essentially adding further layers to the monument of the untruthfulness, if I can put it that way. The distinction is relevant, and as we'll come to, the reasoning behind the misconduct is part of the framework that the court will apply to consider what should be done about it. And it's therefore helpful to keep these broad categories in mind when assessing both the nature of the misconduct and its effect. And in coming to that, the court has a range of responses. Again, Luke is going to look in more detail at some of these and the way that the court approaches it. But by way of a brief summary of some of the things the court can do about misconduct of this type, there is obviously at one end of the most extreme end of the spectrum, strikeouts of a claim, even perhaps a claim which is notionally a runner on its own merits, if it is impossible for that claim now to be properly tried without, if it has been so irrevocably entwined with the misconduct in such a way that disentangling it will be impossible, the court may consider striking out the proceedings or staying them. There is the possibility, if evidence has been obtained improperly or documents have been obtained improperly, that adverse inferences can be drawn as necessary. That is particularly relevant in cases, for example, of suppression of evidence or destruction of evidence. Discharge of injunctions or interim orders. We're familiar, I think, with situations where the improper presentation of interim applications for injunctions or the like can cause the order to rebound at the return date or subsequently when the order is set aside for example, non-disclosure or improper conduct in the application itself. Financial penalties, obviously, costs, denial of interest on a claim or other forms of punitive orders, or perhaps most at the most benign end of the spectrum from the litigant's perspective, simply a refusal of permission to rely on the impugned information. Looking at whether it's possible to draw together a unified approach to this rather than simply saying, well, it depends on the case and it depends on the facts of the individual case. What the court will try and do in all circumstances is strike the right balance. The court will always try and do what is appropriate and proportionate in all the circumstances. And there is an element of deterrent about it. We know that there is a deterrent factor built into the civil procedure rules more broadly. For example, sanctions under CPR 3.9, part of the rationale of the regime, both in the Jackson report and in the authorities that have come subsequently to Mitchell and Denton and the like, is to expressly say that it is necessary to deter a lack of compliance. And the same is true here. It is appropriate for the court to police its own procedures in such a way that other litigants will be deterred from acting in these types of ways. And when dealing with, as we've defined it, extra procedural abuse, it's not so much a question of saying that strikeout is a last resort, but rather is strikeout the right response in all the circumstances. And on the other side of the scale, there is the question of recognizing that if, for example, a claimant has been guilty of abuse of process, a strikeout of proceedings or another particularly strong response might, for example, confer a windfall on defendant. We'll come to one such case later, but the court will have in mind that whilst not necessarily, whilst unambiguously improper conduct needs a strong response, equally, the court should be mindful that it doesn't necessarily grant a windfall on a defendant. If a defendant's a victim of an abusive process, they are not necessarily let off the hook to enjoy the benefit of their own misdeeds. So, with that introduction in mind and some broad principles established, I'll hand over to Luke to look at the principles in more detail, in particular with reference to one case, Zahor, which he's going to take us through in more detail. Luke.
Yes, thank you, Elis, and good afternoon, everybody. I'm going, as Elis says, to talk a little bit about some of the sanctions in more detail, and in particular, I'm going to focus on what you might think of as the most draconian sanction, which is striking out for abuse of process. There are, as Ellis said before, a great number of sanctions which the court has at its disposal if it wants to punish litigation misconduct. Some of them are general, for example, costs, debarring interest, and so forth. Some of them are specific to particular sorts of applications, for example, discharging interim orders where there's been a breach of the duty of full and frank disclosure. But really, at the end of all of those sanctions, the most severe is striking out for improper conduct. And that is the one that I'm going to look at in more detail. I'm also going to come just after that to look at the circumstances in which you can get a judgment set aside for fraud, because it seems to me that that's a close cousin of striking out for abuse of process. So those are the two main areas that I'm going to focus on. But by way of setting the scene, an introduction or some context, I'm going to talk a little bit first about some litigation from the 2000s, which was the litigation involving Mohammed Zahur and the Istil Company. And as Ellis indicated, this was some litigation that I was involved in. Surprise, surprise. Barristers love talking about cases that they were involved in, and I've managed to shoehorn one in. So there we go. Gold star to me. The litigation, this actually was, I think back on this with a sort of wistful eye, because I think that this case was probably one of the first, or this litigation was really quite possibly the first proper piece of litigation I was ever involved in practice. Once I'd done a couple of sort of winding ups and bankruptcy petitions, I somehow got involved in this case early on this run of cases. And the facts of the litigation were a bit complicated and in many ways rather odd. So you start really with the protagonists, Mohammed Zahur, who was the founder of a steel company, a steel mill in Donetsk in Ukraine, and took control of that mill during the course of the 1990s. I often reflected in the dark parts of the night what you actually had to do to take control of a steel mill in Ukraine in the 1990s, probably all sorts of things best not remembered. But he ended up with that steel mill. And he had an old school friend called Sahel Massoud, who was a US citizen who was operating a financial consultancy. And by 1996, Massoud, who was my client, was working for Istil, which is what the company that ran the steel mill later became called. And he was performing services under a couple of consultancy agreements. Massoud's case was that these agreements from 1996 were amended by two documents, which I've put in bold on that slide, called the IPO letter and the Donetsk letter. And the terms of them don't really matter, but they were foundational to Massoud's case. Those were amending documents. And all proceeded reasonably well until the relationship between Massoud and Zahur broke down in 2002. And there was an internal inquiry at Istil which discovered that Zahur had allegedly been funneling off corporate opportunities to a company, a Cypriot company, which he owned called Reventox. Um, it seems that I can't, the details of it escape my memory slightly, but it seems that they were once at a drinks party when I think an ambassador to Pakistan suggested that they might want to branch out from steel rolling into arms dealing. And it seemed like a good idea, or certainly taking commissions on arms contracts. So I'm being a bit glib, but they branched out anyway into dealings with arms contracts. And this is how it came to pass that they were dealing in this space, and it was said that that Zahur was funneling some of these opportunities into this company of his own rather than leaving them for the benefit of Istil, and that would have been in breach of his director's duties to Istil. Um, Masood was at this point a director of Istil, and proceedings were commenced by Istil against Reventox for remedies arising out of the diversion of these corporate opportunities and against Zahur. And a worldwide freezing order was obtained against Zahur. One of the big issues in the case was whether or not, or what the precise terms were of this agreement between Reventox and an entity called Progress, which was the two Reventox was the company, Zahur's company. Progress was an offshoot of the Ukrainian state, and they were the ones that were had the contract between them. And the terms of the contract were uncertain, in particular whether it applied to engines or just hulls of tanks, and what the particular amount of commission was. And this went to how much was supposedly being diverted off to Reventox. Now, one of the really odd features of the case was that, or one of the many features that were rather odd, was that there was this anonymous source called the Istil Friend. And the Istil Friend started to feed documents to Mr. Masood, which were relevant to sort of feeding documents that were relevant to the governance of the company, relevant to the Reventox claim. And these documents were, Masood thought, helpful to his case in relation to this underlying claim against Reventox. And in, I think, around 2002, Zahur, by some means or other, managed to get hold of some of the communications between Sahel Masood and the Istil Friend. And he got a window, therefore, into the dealings between Masood and his lawyers and Istil Friend. And what Masood did when he discovered this was he sought an injunction to restrain Zahur from using those documents. So you can see that those documents, that communication with the Istil Friend, would have potentially been covered by litigation privilege because it was communicating with a third party in relation to litigation, and the third party was supplying documents. And Masood Istil thought that those documents should be restrained from use because it would be a breach of the privilege. Now, among the documents which the Istil Friend had supplied to Mr. Masood were three documents which I've put on the slide there. You can see the bogus Appendix 1, which was admitted in the end by Masood to be a forged document, a document which I've called the Masood Appendix 1, and a document which I've called the Zahur Appendix 1. Now, those three documents were supplied to Masood through this source at different times. And by November, Masood and his lawyers had concluded that the bogus appendix was just that. It was a forged document and was of no use. On the 29th of November, as you can see there, Masood nevertheless swore an affidavit in support of the freezing order against Zahur, in which he exhibited the Masood Appendix 1, but he did not mention that he had previously been supplied with a document, the bogus Appendix 1, that he himself had concluded was a forgery. And the judge, Mr. Justice Lawrence Collins, in the application that I'll come to in a moment, found that in failing to make full presentation of that fact, he'd given evidence which was incomplete, misleading, and also dishonest. And he also concluded, that's the judge, also concluded that the bogus appendix had probably been forged for the purposes of the litigation. Oh, hang on. So Um, yeah, so we come then to the application in front of Mr. Justice Lawrence Collins, and the judge held that in the end that the no injunction should be granted. So the judge, I don't want to dwell too long on this because it's obviously specific to issues of privilege, but the case remains one of the leading authorities on the circumstances in which you can obtain an injunction to restrain the use of privileged information and how the iniquity rule feeds into it. But just as we're on it in passing, and it is of course relevant to the sorts of sanctions or approach of the courts to questions of wrongdoing, albeit specifically in relation to injunctions, it's probably worth just saying a few words about it. Um, Anybody who's looked at this area of the law may remember that there is competition between two principles. The first is what's called the Calcraft principle, which is the idea that once something has been disclosed, it's out of the cat is out of the bag, and you can give evidence of it, even if it was a privileged document. The second competing thread is the idea that the court has the equitable jurisdiction, has the power to restrain the use of confidential or privileged material. So you have these two principles which are potentially in tension. And in the application for an injunction in front of Mr. Justice Lawrence Collins, the judge formulated 6 principles which he found as the way of reconciling these competing tensions. So you can see there, yes, once the document is disclosed, privilege is lost, but the court retains the equitable jurisdiction I mentioned. Ordinarily, the court should grant an injunction to restrain the use of privileged material. There's no balancing exercise to be done because the law of privilege protects confidentiality, and that's absolutely binary. The fact that the truth has emerged is not a reason of itself to override privilege, but there are other factors which can apply to make it improper in extreme circumstances to grant the injunction. I think that the slides are mucking around with me. So, Ellis, are you able to get it back onto? There we are. Okay, thanks. So, this is like being in a terrible anxiety dream when the technology starts working. In this particular case, anyway, the judge declined to grant the remedy, as I mentioned at the beginning, for 2 reasons: basically iniquity and clean hands, and essentially, or lack of clean hands. It flowed from the fact that there was, the judge thought, litigation misconduct on the part of Masood. But anyway, moving on through the story, in due course, Masood himself commenced proceedings against Istil and Zahur, seeking various heads of relief. And you can see there that there were claims to 8% of the shares in the group. And this was on the basis of the IPO letter and the Donex letter that I bolded up earlier on. So those were the 2 documents, November 1996, which amended the underlying consultancy agreements. There was said to be a claim for some cash under those agreements as well. There was said to be a beneficial interest in a 5% shareholding in the company, which had been acquired in the names of some nominees, again under various documents, including but not limited to those amending instruments. Masood was claiming unpaid salary following an unfair dismissal, as he alleged. And then there was a malicious falsehood claim against Zahur, who was said to have misquoted the Lawrence Collins judgment on the Istil website after Masood was ejected from the company in a way which sought to cast aspersions on Masood's honesty. So he essentially deliberately put up a misquote of the judgment online. And to that, Istil and Zahur said that the amending instruments were forgeries, that the nominees had acquired shares for Zahur, so they denied the beneficial interest of Suhail Masood in those shares, that he was fired for good reason, and then for good measure, Zahur also sought to bring a claim against Masood personally for fueling on the Reventox claim, which by now Zahur, who had taken control of Istil and was therefore both in control of the claimant and the defendant, had managed to dispose of. What was the result of these claims? Well, the case was tried in front of Mr. Justice Peter Smith. As I say, I was involved in the case. I appeared as a junior for Richard de Lacy. If anybody ever met Richard de Lacy, they'd know that he was an absolutely superb advocate. And Richard treated everybody to, I think, an absolute masterclass in old style barristerial demeanour and comportment, complete with sort of long, slow pours of water, lots of sort of, I put it to you, Mr. Zahur, goose stepping behind counsel's rows and all of this sort of stuff. But he did an absolute phenomenal job. You could see that Peter Smith was obviously extremely respectful of de Lacy and regarded him as something of an intellectual titan. I'm not sure I quite got the impression that the feelings were reciprocated, but anyway, it was a relationship of respect anyway, flowing in one direction. Peter Smith had a problem because during the course of the trial, he came to the conclusion, or at the end of the trial, weighing the evidence, that there had been no fewer than 52 documents that had been challenged as forgeries. So he had a vast, vast job in trying to work out what was true and what was false. And he came to the conclusion that all of the protagonists in the case, Masood, Zahur, another couple of characters, had been involved in wholesale forgery of documents on both sides and had been lying on oath. And he thought that if you just looked at Masood's conduct in isolation, there was more than enough to justify striking out the claim for abuse. But the problem that he had was that he felt that if he did that, it would deliver a windfall to Zahur. This is the point that Elis mentioned before, a windfall to Zahur, who himself had also been guilty of gross litigation misconduct. So as a result of that, the judge didn't want to strike out the claim, and he sought to do the best he could in relation to the evidence where possible, and deciding things on the balance of probabilities where he had to. Sorry, actually just staying with that slide, what you can see is that in the end, he decided that the bonus and share claims, well, he threw them out because they were based upon amending letters that it turned out that Masood had forged. Likewise, the 5% agreement was dismissed. Well, the 5% claim to shareholdings was dismissed on the terms that Masood had put forward, because that was also based upon forged documents. But the judge found that there was an alternative unpleaded case of constructive or resulting trust. So Masood succeeded on that. The judge felt the costs argument against Masood. Masood was wrongfully dismissed and was awarded salary. And there was a case of malicious falsehood, but because he had suffered no damage, Masood had suffered no damage, the judge awarded him nominal damages of £1. So that was the best that the judge could do, sort of hacking his way through the thicket of lies. It went to the Court of Appeal. And in the Court of Appeal, there were two key arguments. The second, just dealing with it quickly, was this pleading point. The case was taken by Zahur that it was wrong of the trial judge to find for Masood on the basis of a case that had never been pleaded nor put to the witnesses in evidence in cross-examination. And the Court of Appeal agreed with that. So the case gives you a good example of why the court should not go off on a frolic of its own and should stay within the bounds of the case that the parties have pleaded. But on the strikeout point, which is the point that interests us today, the Court of Appeal decided that there was a jurisdiction to strike a case out for abuse of process where the abuse was so serious that it would be an affront to permit the claim to go forward, an affront to the court, an affront to justice. And that was the case, as I say, even where the trial has come to an end, but that it would be a very, very rare situation in which that happened. The Court of Appeal, however, thought that it was wrong for the court for the trial judge Peter Smith to have engaged in a balancing exercise. There was no balancing to be done when you're deciding whether to strike out on the part of misconduct by the claimant. So the judge had taken the wrong approach, but nevertheless, the judge had come to the right conclusion because it wouldn't have been appropriate to strike out the claim after the trial. So the judge had got to the right outcome, but through the wrong path. And what the Court of Appeal said really was, look, when you get to the end of the trial, the options that were open to the judge was either throw it out on the basis of the evidence or throw it out as a strikeout. And on either basis, you've got to give reasons. So essentially, there's no real point striking it out with reasons as opposed to trying to decide the case, doing your best and then giving reasons. So that was the Court of Appeal's approach. Now, all of that set the scene for what has become now the leading case on circumstances in which the court will strike out claims for certainly dishonestly fabricated claims by claimants, which was this decision from 2012 of the Supreme Court in Summers and Fairclough Holmes. And this was a case which must be, unfortunately, pretty common, where a claimant was fabricating or giving false evidence to bolster a claim. So Elis, a few minutes ago, divided up the sort of different categories that you can see. Those, claims which are completely fictitious versus claims which are genuine but being bolstered with false evidence and so on. And this was a case in the latter category. The claimant had hurt himself at work, suffered various injuries to his hands and heels, which he said meant that he was basically prevented him from working in the future and left him constantly in pain. The defendant had admitted liability, but there was to be a trial on quantum, and the claimant's schedule of losses were pretty massive at 800,000 on the basis that he wasn't going to be working again. The defendant obtained surveillance evidence. It sort of reminds me of this, if anybody remembers Little Britain, where there's David Williams and Matt Lucas's character, where every time David Williams disappears, Matt Lucas gets up out of his wheelchair and starts sort of climbing ladders and kicking footballs and then sits down again. And it was a case where the defendants here had got recordings of literally of the claimant playing football and that sort of thing. So the defendant amended its defence and alleged that the claimant had been involved in gross, dishonest, deliberate exaggeration. This was an abusive process, and that the court should strike out the claim in its entirety. And at first instance, the trial judge concluded that the claim was indeed substantially fraudulent, but considered that the authorities did not allow him to strike out the case at a trial stage. So the judge waded on and did the best he could to sift the genuine claim from the false parts of the claim, and decided that there was a genuine claim for 88,000. That was the genuine injury and consequential loss. The Court of Appeal also concluded that it was bound by authority to find that there could be no strikeout at the conclusion of the trial. So there was some competing authority with the Zahur case on that point, and that the judge had been right to do his best and to try to find and give judgment for the 88,000, which was the genuine part of the claim. So the question which went up to the Supreme Court was, did the court have a discretionary power to strike out the genuine claim for dishonesty? And if so, did it apply at the end of the trial where the genuine part of the claim has even been quantified? And the court concluded that yes, there was that power. There was a striking out power in those very wide terms, but in this particular case, it would not have been appropriate for the court to exercise it. So the judgment for £88,000 stood, and the decision of the Court of Appeal was therefore upheld, albeit on different grounds. And what I've done on this slide is I've tried to set out the key parts of the authority, the key propositions which emerge from the authority, which is that the court has power both under the inherent jurisdiction and 3.4 to strike out a statement of case for an abuse, and that's the case even if you've had a trial. So it preferred the Masood and Zahir line of authority on that, but that it would always be an absolutely exceptional circumstance in which the court would strike out a case because it effectively or potentially removed a substantive right. And once you had got to the end of the trial and the case had, and the claimant had established that they did indeed have a genuine claim, it actually gave rise to issues arising under Article 1 of Protocol 1 because you'd be denying the claimant the fruits of their judgment. And the court went so far as to say it would be extremely difficult to think of circumstances in which it would be proportionate to strike out the claim. I've gone over the time I think I said I would, so I'm going to be extremely swift and just touch on this other line of cases. This is the circumstance in which the courts will allow a claimant, a rescission claimant as they call it, to set aside a judgment when it transpires that it's been procured by fraud. And the leading authority is again a Supreme Court case. This is Takhar and Gracefield, more recent. So it's a case from 2020. And the court concludes in that case, as you can see from the bottom of the slide, that where the judgment has been obtained by fraud and fraud wasn't pleaded or argued at the trial, it is open to the claimant to adduce evidence of fraud at the trial and to have the judgment set aside on the basis of that fraud, even if it could actually have obtained, the claimant could have actually obtained that evidence at the time of the trial. So it's an independent cause of action. It's not a form of procedural application. It's a fresh cause of action, and it's analogous to deceit. But you do need to show that the fraud was material to the judge's decision in the sense that it probably made a difference to the outcome. So there are some restrictions to the operation of the principle. The court retains the jurisdiction to deny set aside in certain circumstances, and these are where the fraud was originally argued at the trial, or where the applicant took a deliberate decision not to investigate the possibility of fraud at the trial. But it would be rare for the court to exercise a discretion to deny a remedy on either of those two bases, but those limitations are there. I'm sorry, I suppose I'm apologising predominantly to Elis. I'm sorry, Elis, I've gone on a bit longer than I said I would, but that's a bit of a whistle-stop tour. I'm going to hand back then to Elis, who I think is going to look at some of the more recent cases of litigation misconduct.
Yes, before I go on to this, I'll mention just very briefly by way of coda to the Fair Club decision that, as some of you will be aware, once the decision was made in Fairclough not to strike out the claim, Parliament actually legislated in the Courts and Justice, forgive me, the Criminal Courts and Practice Bill, I think, Section 58 provides that where now, and this informs pretty much all personal injury litigation, where a person is found to have been, to use the expression, fundamentally dishonest, the court is enjoined to dismiss the entire claim, including any genuine damages, as it were, unless it would be cause significant injustice if it does so. So that was, I think it's fair to say that Summers was a decision that was unwelcome to the insurance industry, and pressure was brought to bear to include that change. And it has very much changed the complexion of personal injury litigation, and allegations of it, as they are summarised, FD, are now extremely common. Moving on to this much more recent case, the citation is in one of the early slides. I'll call it Astor. This was the case that I read, which made me think that a talk on this subject was uh, uh, timely, because it's one of those cases where you read the facts and um, really quite an extraordinary case, I think. Um, the underlying facts are not that important. It is a substantial case currently still wending its way through the courts, circa $400 million civil fraud claim. It's based on a stock lending fraud structure where the uh, ultimate defendant, a Mr. Sklarov, uses a variety of corporate structures known as um, Aster Asset Management, or similar names that some may think might be designed to give the impression that they're connected to the obviously well-known and wealthy American family, the Astor dynasty. They are not. And so the situation that we got to in the proceedings is that there is a worldwide freezing order. There have been various interlocutory skirmishes. And the claimant makes an application for summary judgment, and they make an application for summary judgment based on information that has been obtained from the defendant's litigation solicitor. And the way that the information was obtained was that the claimants, or people acting on behalf of the claimants, have engaged a firm known as Black Cube, and it seems that Black Cube is a consultancy with links to or set up by former Mossad Israeli Secret Service individuals, who seem to carry out sting operations. This is not the only case in which this has happened. There's a Canadian case referred to in the judgment where this consultancy targeted a sitting judge and essentially tried on a number of occasions to approach him and get him to say things that might suggest, for example, that he was anti-Semitic or had an animus against their client in that case. And here in Astor, what happened is that these individuals had a meeting with the defendant's litigation solicitor in the guise of a prospective new client who had a claim potentially or was involved in litigation similar to this case, and managed to get him to divulge information about this case to really quite a significant degree, uh, including perceived strengths and weaknesses of the case, aspects of their litigation strategy, aspects of their settlement strategy, and so forth. Those meetings were secretly filmed and recorded. Those video and audio recordings were provided to the claimant, who then applied for summary judgment. One of the things that jumps out at you straight away, I think, when I put it like that, is this is obviously quite different to a lot of these cases where in Zahor, for example, or in many cases where evidence is obtained illicitly or is concocted, the lawyers will be completely unaware of this. They will be presented with the information. They will take their client's instructions on it, and they will treat it as though it were legitimate because that's what their client says. Here, it would seem that there was no question that they knew how this information had been obtained. And it wasn't as though they were trying to conceal that. It was very much upfront in the application that this was obtained by from the defendant solicitor, effectively. And I don't know to what extent this was made explicit, but it was by way of a sting. And there's a real sense of frustration in the judgment. You can see it when the judge is explaining this, that he is not being told to what extent the claimant itself was aware of this, what methods were being used, and so forth. In terms of the claimant's position, they accepted that the methods employed to obtain the information were unethical. They denied responsibility or the use of those methods. They argued that essentially, and you may think this is unattractive, they argued that it was all the defendant's fault, the solicitor's fault, because he shouldn't have disclosed any of this information. To the extent that he did, any complaints that the defendants had should be directed at him. And apparently, the phrase "there should have been a nil return" was something of a mantra during this hearing. They also said that to the extent that they didn't accept that they'd obtained any privileged information, which I'm bound to say seemed like an ambitious submission, and to the extent that they had, they invoked the iniquity principle, and they also denied any unfair advantage. And regardless of the any problem with the way that they got this information, summary judgment should be granted in any event. And they said it would be completely disproportionate to strike out the claim in circumstances where that would leave the defendants free to enjoy the fruits of a fraud. And that, of course, refers back to arguments made in Zahor and others. The defendant's position, perhaps not entirely surprisingly, they had obtained illicit information that was privileged. By definition, it was sought and obtained with a view to obtaining an unfair advantage. They can't forget it, they can't ignore it, they're not going to overlook it. It's going to influence the claimant's further conduct of the litigation, and therefore it's an abuse of process in that extra procedural sense that we were discussing. And therefore, the appropriate response is to strike out the claim regardless of its merits. The judge's position was fairly squarely that the claimants engaged in unethical behaviour with a view to obtaining an unfair litigation advantage. He commented that that's anathema to the fundamental basis or premise of civil proceedings. And he commented also that the defendant solicitor was skillfully and tenaciously steered by the investigators into discussing various aspects of the litigation and settlement strategy. He rejected the contention that this was the solicitor's fault. It's impossible, I think, to read this, and the judgment obviously goes into significant detail on exactly what happened. He'd been targeted by professionals in bad faith, and I think it's impossible to read the judgment without thinking this is something, I think, that admittedly, whilst it's perhaps more likely in certain forms of litigation than others, it is something I think that could be attempted in any context. I alluded earlier to the possibility of fraud and phishing scams by AI, for example, or deep fakes. We know that people fall for these things. And I think I think it's impossible to read this judgment without an involuntary shudder at the possibility that something like this might be attempted elsewhere, and you can really see the potential for needing to deter it. At the end of this slide, you can see that there's a reference. The claimant solicitors were at the time were unaware of the engagement of the investigators by the clients. The firm at the time, and you can work out fairly easily who that was from the earlier judgments in the litigation, refused to look at the video files or listen to the audio files. They were promptly replaced by the claimant's current solicitors, who appear to have no such inhibition. I think that's, whilst it's in its wording relatively restrained, it's very difficult not to read that as inherently critical, I think. And the judge found that the claimant's attempt to distance themselves from the methods that the investigators employed were effectively artificial and hypocritical. And also, as I said, there was no attempt by the claimant's new solicitors to hive off the illicit information or rely on only proper sources of information. On the contrary, they enthusiastically made use of it. Nevertheless, he didn't strike out the claim. A combination of some culpability on the defendant solicitor's part, clearly, regardless of the sophistication and the skill with which he was pumped for the information, he shouldn't have revealed it. Uh, there was a desire, I think, on the judge's part not to allow the defendants potentially to get away with serious wrongdoing. And also, and I won't go into precisely the details about this, but you can see them from the judgment if you care to read it. Um, they may not be out of the woods yet, is essentially, I think, is the executive summary. He did strike out the summary judgment application. He did make punitive orders as to costs, and he also granted permission to appeal, remarking that it may be thought that he's come down on the wrong side of the line here, and the Court of Appeal might not be as lenient. So we may not have heard the last of this, but for the moment, at least, the claim survives. But it's both an interesting read from the perspective of just how extreme some examples of this behavior can be, and also a useful worked example of the relevant legal principles to be applied in this situation. Very briefly, and this is another recent case, which is an interesting read. Uh, Again, the facts not particularly relevant. It shows perhaps a more prosaic example of misconduct, but again, the sort of thing that you can expect or you can envisage coming up in a case in which you're involved. A claim, this is a claim involving Lithuanian companies in the Insolvency and Companies Court. And the claimant's main witness, a Mr. Jackstis, gave evidence in person. The court had approved the use of a remote link for a Lithuanian lawyer, a Dr. Miliauskas, to view the proceedings. Mr. Jackstis got in the witness box. He was giving evidence through an interpreter even before any outward problems transpired. He was noticeably pausing for quite a while before answering. And counsel for the defendant noticed that she could hear what's termed an interference coming from his direction. And the interpreter also confirmed that that was something that they could hear. And it transpired that Mr. Jackstis was wearing a pair of smart glasses, which was connected to a call on his mobile telephone. And although the judgment doesn't go as far as to find as a fact that it was definitely happening, it appeared extremely likely that what was happening is that Dr. Miliauskas, who's on the live link, was effectively coaching Mr. Jackstis as to what evidence he ought to be giving. He was invited, in responding to these questions, to allow his mobile phone and its metadata to be checked. He agreed, but before it could happen, his counsel informed the judge that, quote, Mr. Jackstis had informed him that the day before that he'd been robbed of his two mobile phones and his passport. And then slightly archly, the judge continues, no copy of a police report was produced by Mr. Jackstis to the court. No witness statement was produced setting out the details of the robbery. I think that has a similar ring to it, no pun intended, of the phone that was inadvertently dropped into the North Sea by Rebecca Vardy's agent in the Wagatha Christie trial, or as I've also seen it referred to, the Ragnarok trial. So the consequence of all this was devastating to Mr. Jackstis's credibility. His evidence was entirely disbelieved. The claim was dismissed on its merits, I should say, not necessarily as the result of any abusive process. But whilst it's impossible to know exactly what might have happened if that incident hadn't happened, whether this was a situation where the claim wouldn't have succeeded anyway, and this was an attempt to bolster a false case, or whether, as I think is more likely, it was someone who was hoping to bolster their case, a genuine case, but by improper means. It would seem fairly clear that it backfired fairly spectacularly in this case. Um, so those are two recent cases of misconduct and how the court has dealt with them. We've run over slightly. Thank you for sticking with us to the end. I don't know if there are any questions or anything that we can deal with. I don't think there are any questions in the Q&A box. So if anyone has any questions or any observations they'd like to make, do feel free to do so. But otherwise, uh, thank you very much for joining Luke and me.
Bye bye. Thank you.